Hi friends, in this video we are going to deal with the important judgment titled Ratan versus State of Madhya Pradesh pronounced on 17th December 2021. This judgment deals with that mere exhibition, brandishing or holding a weapon openly by offender to threaten and create fear or apprehension in the mind of the victim is sufficient to constitute an offence under section 397 of IPC. To know more about this case synopsis, please watch the video fully. The facts of the case would be that a complaint was lodged by Rajesh Meena alleging that on the intervening night of June 26th and 27, 2012, while he was sleeping in the hut constructed in the field to guard the crops, Ratan, the appellant, along with Raju and Chotu, woke him up. Raju was having a gun with him and he pointed the same towards the complainant's chest and demanded to part with the money. Since the complainant did not have any money, the accused took his motorcycle. Charges were framed. After the trial court convicted the appellant along with the other two accused under sections 392 and 397 of IPC, read with section 11 and 13 of Madhya Pradesh Dacoity Aur Vyaparan Prabhavit Kshetra Adhinayam 1981 and sentenced them. The co-accused Raju was further convicted and sentenced under section 25 1BA of Arms Act. On appeals, the judgment passed by the trial court was upheld by High Court. Being aggrieved, the appellant is before the Supreme Court. The issues posed for consideration are: the first one is whether charge under section 397 of IPC was sustainable since the appellant contended that the firearm had not been put to use. The second one is, would charge under section 397 of IPC be sustainable if there was no material or evidence to indicate that appellant used the firearm irrespective of occurring of the alleged incident. The Supreme Court has held that the use of the weapon to constitute the offence under section 397 of IPC that does not require that the offender should actually fire from the firearm or actually stab if it is a knife or a dagger, but the mere exhibition of the same, brandishing or holding it openly to threaten and create fear or apprehension in the mind of the victim is sufficient. The other aspect is that if the charge of committing the offence is alleged against all the accused and only one among the offenders had used the firearm or deadly weapon, only such of the offender who has used the firearm or deadly weapon alone would be liable to be charged under section 397 of IPC. If that be the position, it would stand established and proved beyond doubt that only one of the accused, namely Raju, used the firearm, and there was neither any allegation apart from a stray sentence, nor was such a charge of having used firearm proved against the appellant. In that light, if the position of law enunciated by this court is kept in view, the charge under section 397 of IPC can be fastened on the offender who actually uses the firearm. In the instant case, since the facts and the evidence does not indicate that the appellant could be construed as an offender who used the firearm, the charge alleged against him and held to be proved by the trial court as also High Court under section 397 of IPC and section 11 and 13 of the alleged Madhya Pradesh Act cannot be sustained. However, the appellant having participated in the offence of committing robbery, which stands established with sufficient evidence, the conviction handed down by trial court and upheld by High Court under section 392 of IPC is sustainable to that extent. The judgment passed by special judge insofar it has convicted the appellant under section 397 of IPC, read with sections 11 and 13 of the alleged Madhya Pradesh Act and upheld by High Court or set aside to that extent. The conviction of the appellant under section 392 of IPC by trial court and upheld by High Court is sustained. The sentence imposed on the appellant is modified to that of the period of imprisonment undergone by him till this day. The fine imposed and default sentence thereof is retained. Friends, to conclude in this video, we have seen that mere exhibition, brandishing, or holding a weapon openly by offender to threaten and create fear or apprehension in the mind of the victim is sufficient to constitute an offence under section 397 of IPC as per Ratan versus State of Madhya Pradesh case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.